It's my pleasure and honor to invite Dean Trevor Morrison of NYU School of Law formally to open the second annual conference of ICON-S.
Thank you, Joseph, and welcome to all of you. It is a real pleasure to welcome you here to the International Society of Public Law's 2015 conference, Public Law in an Uncertain World. So I really just bring words of welcome and some of thanks to you this afternoon. The conference was jointly organized by the Law School, by the Jean Monnet Center for International and Regional Economic Law and Justice, and the Institute for Research on Public Administration. And I do want to thank the conference organizing committee members for all of their work in planning this event, as well, of course, as our very talented speakers and guests for being part of this event. We at the Law School are really thrilled to be hosting this conference. We share ICON's conviction that deep problems of law and policy transcend borders, that legal practice and scholarship both transcend borders and need to be taken up in a transnational, a comparative, a global context. That conviction for us is reflected in a diverse and talented student population, in our visiting and permanent faculty who really come from all around the world and who are actively engaged in issues transcending borders in their own teaching and in their scholarship. For fully 2 decades now, this law school has prided itself on providing a truly global legal education. Last fall, we celebrated the 20th anniversary of the Hauser Global Law School program here at NYU Law School. It's a program that many of you are familiar with, I'm sure, and is a reflection of our own deep commitment to legal teaching and scholarship from a global perspective. And so ICON-S is really a natural extension of our position, we'd like to think, as the, not just a, but the global law school. And so we're thrilled to be hosting all of you. ICON-S itself has deep roots here at NYU, having grown out of the International Journal of Constitutional Law, whose founder, Norman Dorsey, has been on the faculty here since 1961. Norman wears many hats. He is counselor to the president of NYU, as well as our Stokes Professor of Law, and was founding director of our Hauser Global Law School program in 1994, and a founding member of the governing board of the International Association of Law Schools, and is a deeply cherished member of our community. I also do want to take this opportunity to extend, on behalf of NYU, my thanks to Michelle Rosenfeld at Cardozo, just a few blocks north on Fifth Avenue. Michelle stepped down late last year after more than 13 years at the journal's helm. In addition to his work on ICON, was president of the International Association of Constitutional Law for 5 years, from 1999 to 2004, and so thank you for that work. NYU Law's own Grania de Burca, a member of the organizing committee for this conference, as well as our university professor, Joseph Weiler, who's, as all of you know, currently on leave from NYU, working as president of the European Union Institute in Florence, are together ICON's current co-editors-in-chief, and Joseph also serves as editorial director. So I want to thank both Joseph and Grania. Is Grania here somewhere? She must be. Hey, Grania. I want to thank both Joseph and Grania for terrific work in this area and for ensuring that the close connections between the law school, ICON, and ICON-S remain and flourish. Now, before concluding, I also want to take a moment to extend a special welcome and thank you to Sabino Cassese, known to all of you, I'm sure, as Emeritus Justice of the Italian Constitutional Court, as well as a leading scholar, having taught and lectured at law schools really around the world. He also was a visiting global professor here, both in 2004 and 2010. Welcome, Professor Cassese. This is sure to be a successful conference with brilliant speakers for plenary sessions, wonderful floor discussions on themes that define and reflect the scope of this society. And so again, I am just thrilled to be welcoming all of you here, and I wish you the very best for the conference. And with that, we'll turn things back over to Joseph. Thank you.
Thank you very much, Trevor. So the first thing I want to do is to echo Trevor's thanks to Michelle Rosenfeld, who's sitting here. I know that Norman Dawson is the founding editor of ICON, but in my mind, Michelle Rosenfeld and Norman Dawson are the founding editors of ICON. And it's his vision, his leadership, his energy, his activity, which really took this journal ahead. Federal Express let me down because I was going to give you a little present, Michelle. But I do want to announce publicly that we decided that we now have at the top of our masthead the name of Norman Dawson as founding editors, and starting from the next issue, your name will be alongside Norman Dawson as founding editors. If you don't mind standing up so you can be recognized. And if the present arrives, like the commercial, you lost your credit card, we'll find the time during the sessions. So also a word about ICON-S. The first, grant me, this is not the Palazzo Vecchio and the Sala Cinquecento. We can't replicate that. But we were wonderfully gratified that the number of people who registered to participate in the conference has not fallen down from the first year to the second year. And in 2 years, ICON-S has grown to be a society which has 767 members, which I think for a new society in 2 years is a respectable achievement, and I hope from strength to strength. And I will mention that the idea of ICON-S also was Michelle Rosenfeld. So thank you again, Michelle. Last year there were some voices that, oh, it's so American, we can't have the next meeting in New York, the United States. And my position was, if anybody else steps forward and is willing to host it, they can do it. If nobody does, it will be at NYU in New York. But for next year, we already have 3 bids as a sign of the vibrancy and the attractiveness of ICON-S. And it's the committee tonight will have to decide between Copenhagen, Berlin, and Tel Aviv. So I like that. In Yiddish, we say Gesundheitssorges, happy problems, to be able to choose between those 3 potential locations for next year's annual meeting. ICON-S is intimately connected with ICON. I want to thank Oxford University Press for the second year. Every member of ICON-S gets a free online subscription to ICON. And that will continue. It won't be free, but we will take it. It will be part of the annual registration so that membership of ICON-S is intimately connected with ICON. And one big development, we are going to roll out in the first issue of 2016 a tablet version of ICON. So both for Android and for iPad, so that it could be resident on your tablet, and with all the features you can scroll through the pages, turn the pages, etc., which would give a much stronger feeling of the actual journal in its paper form. Anybody below the age of 50 tells me that in any event, that's the only way they use scholarship today. But I think there's a big difference between a tablet version with the page feel and downloading PDFs. So watch out for that. A last word. One experience we had from last year in Florence, and I'm putting on, I don't know, my Donish or professorial or father, I'm a father of 5 and grandfather of 2. Last year, we noticed that, for example, the morning sessions, the 9 o'clock sessions. So there were a lot of people saying to themselves, well, my panel is at 11, so I will have a nice, comfortable breakfast in Piazza Signoria or some nice place, and then I will stroll up to the Badia Fiesole or to the University of Florence. It doesn't work if you only go to your own panel. If everybody did that, that's a very bad way of playing the prisoner's dilemma. If everybody did that, there would only be the panelists in the room. So out of enlightened self-interest and respect for our colleagues, I ask you to not show up only at your own panel when you are delivering a paper, but participate in the other panels, so that this year will be also from a scholarly and intellectual perspective as successful as it was last year. So now it's my pleasure and honor to welcome Ayelet Shachar, who is giving our open keynote. Ayelet is the professor of law at University of Toronto School of Law and recently has been appointed as director of the Max Planck Institute for Religious and Ethnic Diversity in Göttingen. Congratulations, Ayelet. You all know her work as being very original, anticipating many of the problems that now the world is facing in a real sense concerning migration and citizenship. Her first book created a splash, Multicultural Jurisdiction, and the more recent book on the birthright lottery as regards citizenship is exactly the kind of provocative scholarship that one welcomes. For the rest, I believe that in the day of Google, we don't have to go through a whole list of achievements. You can read everything you want about Ayelet Shachar, maybe also things she doesn't want you to know. It's my great pleasure to welcome you, Ayelet.
Good afternoon, everyone. Can you hear me all the way to the back? Yes? Wonderful. Thank you, Professor Weiler, President Weiler, for this very generous introduction. It's a real pleasure and honor for me to deliver the opening keynote lecture for ICONES 2015. And I want to thank the organizing committee and everyone who was involved in bringing me here. Since we have a multilinguistic crowd, let me welcome you in different languages. So bonjour, shalom, assalamu alaikum, buongiorno. And I'm sorry, guten tag for any other languages. I could go later on, buenos dias. I'm sure I've missed some of you, but really a warm welcome. In terms of what I want to do in my presentation, it's entitled An Uncertain World, Charting Citizenship's New Legal Terrain. And what I will do is I will convey to you or try to persuade you that we are witnessing now in the world three grand processes of change, of reinventing and reshaping citizenship. And I want to suggest to you that these are quite significant, given that citizenship, despite all the claims about its decline, still remains one of the most significant, important political inventions and institutions that we have in the modern era. And obviously, given that we live in a world of greater globalization, interdependence, and also volatility, these changes are dramatic and are likely to affect potentially all of us in the years to come. So contrary to predictions by hyperglobalists and others who have predicted the imminent demise, if not fall, of citizenship and border regimes, I want to suggest to you that the legal distinction between member and stranger is, if anything, back with a vengeance. And this has been the case ever since 9/11. It has gained tremendous meaning and legal meaning since then, and quite starkly may affect our rights and obligations. And I want to suggest to you that today, more than ever before, questions of migration, membership, identity, and belonging have become hot-button issues, pressing issues that are likely to remain at the forefront of public debates for the foreseeable futures. Now, the study of citizenship and immigration has, at least in recent years, been somewhat of an orphan child in terms of public law. And it deals with some of the most foundational issues that we need to care about, the constitutive aspect of the public, the definition of who belongs or ought to belong within the political community, and according to what criteria. And given that these questions are so pressing in today's world, the question of who belongs or ought to belong within the political community, I want to suggest to you that precisely in these uncertain times, these questions should again become relevant, become important, become central to some of our discussions, or a different way to put this would be to say that it is time to bring this orphan child back into the fold, back into the family of public law, where it squarely belongs. So that will be one of the themes that I will try to advance in my discussion with you today. Now, my presentation is based on a new book, which is entitled Olympic Citizenship, which will be published by Oxford University Press. And the question that I will try to focus my presentation on is, what is the current state of citizenship? And no less significantly, what might be its future in terms of principles of equality and participation in an uncertain world? And the stakes, or at least I will try to convince you, the stakes are quite high. They are quite high because we need to rethink basic concepts of public law, questions of sovereignty, questions of territory, and questions of the relationship between different levels of law as we define who belongs within the political community, who constitutes the public, the demos, in whose name our laws are enacted. Now, in the interest of time, I will divide my presentation into three parts. First, I will argue that forecasts predicting the demise, the fall, the death, whichever term you want to use, of citizenship have been, just like the reports about Mark Twain's death, greatly exaggerated. Second, I will emphasize the centrality of public law in shaping and reshaping the boundaries of the political community, the boundaries of membership boundaries, as well as technical borders. And quite literally, what citizenship and immigration and public law more generally does in this field is shape the contours of the body politique. Now, typically, when we think about public law, say if we think about constitutional law, we think about rights protections, we think about remedies, we think about limits on the exercise of executive power. When we turn to the topic of citizenship, however, what we see is a somewhat different picture. We see a much greater focus on the regulatory exercise of law, on law and order, on enforcement, and far less use of mechanisms of oversight and judicial review. And partly this is due to historical reasons, the concept of sovereignties, concepts such as plenary power doctrine, or what would be called a royal prerogative in the UK. But given the significance of citizenship regimes, this is, at least I will argue, this is something that has to be changed, or we have to find new mechanisms for some degree of oversight. Otherwise, there really is a concern about power being used without limits. Third, for the bulk of my talk, I will argue that in a world of uncertainty like our own, the standard way in which we think about citizenship, the standard way in which you will find debates in the literature occurring, is a very camp-like debate between open borders and closed borders. And this dichotomy between open versus closed, I will suggest to you, no longer applies in the world today. That is the most interesting and in some ways really quite perplexing feature of what we see, is that states acting alone or in concert are actually doing both. They're restricting their borders quite significantly, but they're also opening them at precisely the same time. And it's really this tension, this dialectical kind of interaction, which is fascinating to observe, and also for us as lawyers raises very significant questions about how to deal with this diversity, with this duality of openness versus closure. And again, it is occurring simultaneously. And not only is it occurring simultaneously, what I will try to show in my presentation to you is that there's actually quite an organizing feature in terms of this selectivity of openness versus closeness. The selectivity I will define in the following way. States are quite willing, indeed they're quite eager to accept certain kinds of migrants, specifically the highly skilled, the very wealthy, people who they see as potentially contributing to their own growth and innovation and potential success on the world stage. So that's where we would find this selective openness. On the other hand, for those deemed either too different or unwanted, we actually see the borders closing, 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 and closing down, and in very sophisticated and truly innovative ways. So this is why it's still a puzzle. How do states do that? And again, they're doing this using multiple sources of law, local, domestic, transnational, international, supranational. They'll work with whatever tool exists. So it's really no longer just a national story, but the intention is still to preserve those membership boundaries. So that's partly what I will try and convince you. And I want to suggest to you that this is still a puzzle. It's a puzzle in terms of just understanding how this is done legally, and also what the normative consequences are, what the rights consequences are, what this might mean for the future of citizenship. Now, in order to make this more concrete, this selective openness and restrictive closure, this dualism that I've described to you, occurs along three interrelated axes or lines, what I will call the territorial, the cultural, and the economic. And it's really these three dimensions which I will try to persuade you that are, first of all, occurring, and secondly, are interrelated and are very significant in terms of the rights ramification and the recalibration of citizenship and border regimes in the world in which we reside. And as one scholar put it, the reason why it is interesting for us to look at these laws, which I must convey to you, some of them are extremely technical, so I'm not going to go into the technical side, but nonetheless, the reason why I would try and persuade you that it is quite significant to look at these laws is because they serve as public statements, so to speak. Public statements about what? Public statements about who we are, who we want to be, and who we want to become, and who is worthy in quotation marks here, to join us. So for all of these reasons, the definition of the demos, the fact that public law is used here not as rights protecting as much as it is used as a regulatory tool, for all of these reasons, it is time to look at the use of public law in terms of defining the boundaries of the community. Now, public law is present at every major juncture of the redefinition of the territorial, cultural, and economic dimensions of citizenship. And it really, the way in which public law operates here is fascinating because it actually endows those in power with a whole new means to define the boundaries of the community, to define the legal boundaries of inclusion and exclusion, mobility and immobility, while frequently doing so behind and beyond open democratic debate. So for all of these reasons, it is time to look at these issues. Now, by charting this legal reconstruction or new cartography of borders and membership boundaries, I seek to show you the tremendous creativity, and really you will be surprised, I was surprised when I studied this, the tremendous creativity of the lawyers who invented these policies, but also the tremendous risk. It's a tremendous risk which attaches to public law when it is used to define these much more flexible and accountable, dynamic, use whichever term you wish to use, ways of exercising sovereign authority in determining whom to admit with open arms, whom to keep at bay, and whom to remove quite expeditiously. So crossing disciplinary boundaries pretty much in the spirit of the ICANN Manifesto and exploring some of the most significant developments in citizenship, immigration law, and practice in today's world, I want to take you with me on a journey, hopefully a fascinating and surprising journey, to shed light on some of the really hardest questions about the current state of citizenship and its potential future in a world of uncertainty. So without further ado, let's turn to the first dimension. And here I will ask you to look at the handout. The first dimension that I will discuss with you is the territorial one. Changes to the definition of membership boundaries and mobility. Now, as several commentators have noted, no other source of tension and anxiety has been more powerful in the West than the fear, both real and perceived, of huge waves of future immigration from poor and weak states in the years and decades to come. Now, many of these fears remain empirically unfounded, but that is besides the point. What matters here is the public perception of risk, of fear, of a sense of invasion by unwanted migrants, the feeling of loss of control. Now, in response to precisely these kinds of anxieties and uncertainties, we have seen governments throughout the world utilizing, as I mentioned earlier, different sources of law to invent and implement a new vision, a multi-layered, a complex, a dynamic vision of what the border, the physical border, what used to be the physical border, currently is. And this new border, which is partly depicted in the two images that I've duplicated for you here, is a border which I will call the shifting border. Why is it a shifting border? It is a shifting border because it is a border that is created far more through the words of law than through any fixed territorial marker, as would be the image of a border when we looked at a world atlas, for example. So it's this ability to use law's admission gates, to use the words of law to move the border quite flexibly, to stretch it quite far outward, or to bleed it quite deeply into an existing territory. All of these elements constitute what I will refer to as the shifting border, and this shifting border has quite dramatic ramifications for the rights of migrants, especially irregular migrants, but also all other non-citizens which reside in a given territory. So to make this more concrete, I want you to consider the following examples. Some of them are domestic, some are comparative, some are from near, some are from far, but I want you to get a sense of the legal creativity involved in these issues. So the first image, what I called Exhibit 1 here, refers to a major US reform of its immigration law, of the Immigration Regulation Act, and the procedures that have been introduced. One of them, which I will speak about, is called expedited removal. Now, expedited removal was introduced into law in order to allow frontline officers and border agents in the United States not only to expeditiously return undocumented migrants if they are stopped at the border. That's a very traditional conception of law. If someone comes in and has no authorization, immigration officials or border agents are permitted to turn him or her back at that moment, at the physical territorial point of entry. But what expedited removal, this new legal technique, does is something quite different. This new technique permits immigration officials, or in fact any authorized agent, to explore the legal status of a person within the US territory up to 100 miles from any US land or coastal border. So this is the orange kind of line that you see marked here. This 100-mile territory I will refer to as the shifting or the moving border, which, as I mentioned earlier, removes it from a fixed territorial location and actually brings the border inside into the territory of the country. Now, this legal change, you might say, is insignificant. 100 miles, who would care? It actually turns out that these 100 miles are quite significant for a host of reasons. I'll just mention a few. The first one is within these 100 miles, what's created, or what has been referred to as being created, is a constitutional light or constitution-free zone. By this, I mean to say that within this 100-mile zone, enforcement agents are permitted to set up checkup points at any point in those 100 miles, whether on a highway, whether on a ferry, on trains. For those of you who are from New York, this is actually quite a regular practice now on Amtrak's Lakeshore, for example. So you might just have agents coming in and saying, what is your legal status? Do you have a right to stay in the United States? And usually we would expect such surveillance to occur, again, when we cross territorial borders or interstate borders, international borders. That's no longer the case. We have regulation now occurring of one's status within the territory of a sovereign state, done explicitly through its own legal regulation. So this is an interesting change. Now, if I've not yet convinced you that this matters, let me just give you a few more statistics to show you why this 100-mile zone actually matters quite significantly. So in terms of data, the most recent official US Census data actually tells us that within this 100-mile zone, the orange zone here in our image, we have, in terms of residency, about 2/3 of the US population. A different way to put it is that 200 million people actually reside within these 100 miles from the US border. So this change, again, is quite dramatic in terms of its impact. So more than 200 million people are now subject to this constitutional light or constitution-free zone. Another way to put it is that the whole state of New York is within this zone. Florida is within this zone, and other migrant magnet kind of states. So in short, this is a significant change, but I want to tell you that potentially in the future, we might actually see the whole territory of the United States falling under the either constitution light or constitution free zone, because DHS, the Department of Homeland Security, which is the government agency implementing this policy, has gone on record, and they have regulatory changes prepared to say that the border should in fact apply nationwide. So anywhere within the US, potentially, we could have this shifting border. So that's one example. Let me provide you very quickly just two other examples. North of the border, if we look to Canada, here we find a different idea of the shifting border. Again, purely using admin law, public law tools to redefine the border. Given its geopolitical location, Canada is less concerned about physical entry through a land border and much more about flights coming in. So Canada's legislature, about 10 years ago, our parliament came up with the following brilliant idea. They said, why should we govern our borders when people arrive at Canada? We should actually try and get them before they leave either their country of origin or their country of transit. And this is really what we have seen. So here the shifting border occurs it doesn't shift into the territory, it shifts outside, literally to the four corners of the world. So many of you who would, if you were to travel to Canada from Asia or from Europe, you will actually have your passports checked and your immigration status confirmed before you embark on a plane. That is before you ever set foot on the journey towards Canada. So now border control occurs as a matter of course, literally thousands of miles away from the actual territorial border, and this is part of a formal policy. And again, just to give you a sense of what the official agencies would refer to this as, here Canada's Border Service Agency says that the intention is to push the border out, literally to push the border out as far away as possible from the actual territorial border. So again, just to give you that sense, it's the words of law, it's the creation of law, creating this mobility and moving the border, in this particular case, far away. Now, for the Europeans in the room, this might not sound too new. This is that we see in Europe, the analog would be the policy of externalizing or outsourcing migration control. Again, with very dramatic implications in terms of the extraterritorial application of rights. Should rights apply in an extraterritorial fashion, given that power here is exercised in an extraterritorial fashion? The position of most states is that rights should not attach to such exercise of authority. I would beg to differ, but we can talk about this during the Q&A. Just to give you one last example of the shifting border before we turn to the cultural dimension. So in terms of a third example, Australia, which you see again on your handout, this is the bottom image. Australia has a policy which it calls the excision policy. It was introduced through the Immigration Amendment Act of 2001, amended and changed in 2005, and then again in 2013. And here, Australia, through its excision policy, tries, as explicitly stated in their legislation, to suggest that people who actually reach Australian territory, even if they landed, even if they physically arrived there, have never arrived legally because they have arrived in this new zone, which is called the excision zone. If you reached the territory and fell into the excision zone, Legally, you have not arrived. Again, if any of you know anything about refugee law, this means that you're not subject to protections that you would have been entitled to had you reached the territory. So the fact that you reached the territory physically no longer legally means that you've reached the territory, again, with very dramatic implications. So as in the US, the position now since 2013, and this is through a legislative change, is that the entire territory of Australia is now subject to the excision zone. So if you came without permission to Australia, even if you're there, even if anywhere in the territory for whatever period of time, it doesn't matter legally, you have never been there. That means that you can be removed automatically. So that's the territorial dimension. We can talk about it later on during the Q&A. Let me turn quickly to the cultural dimension, the second dimension of change. And in this cultural dimension, again, we see public law responding quite powerfully to the notion of growing uncertainty here in the context of a very powerful backlash, at least in Europe, against multiculturalism. So here, let's just shift to the second page of your handout. Concerns about the question of cultural integration of immigrants have led in Europe to quite a set of different changes. We have seen the introduction of what are referred to as pre-entry examinations, mandatory language and civic integration tests, the requirements that newcomers sign integration contracts, and various other means. But the means that I want to talk to you about are actually the new citizenship tests, which have been introduced across Europe. And these citizenship tests, as one scholar put it, and I'm quoting, are unusual in their intrusiveness and the intrusiveness of the questions about gender equality, religion, conversion, politics, marital relations, promiscuity, and culture. Now again, to make this more concrete, I want to give you a sense of the kind of questions that newcomers might be asked in terms of the redefinition of membership boundaries. And the examples I will draw on come from Germany, from one of the German states, and these questions have since been changed. There's now a federal test, not a state-by-state test, but I do want you to hear the tone of the question because they're quite different than what we would find in citizenship tests, say, in Canada or in the United States, where usually you would be asked about the geography of the country, its history, some elements of the basic structure of governance, but you'll see it's quite different from the kind of tone that we would hear in some of these tests in Europe. So just to give you two examples, which I've selected for you. So let's travel in our minds to Germany for a moment. I'll do it in English, though. So here are two sample questions that I've collected for you. The first one, and again, imagine the context. This is a citizenship interview, a naturalization interview. You wish to gain the status of full membership in a country. People are usually quite nervous under those circumstances. So this is one of the questions that I want to convey to you. Your adult daughter or your spouse would like to dress like other German girls and women. Would you try to prevent it? If yes, by which means? Now remember, this is a test, this is an interview for your gaining of status from the state. What in the world are you supposed to answer when you get this question? Are you supposed to say that you will permit your daughter and spouse to dress like other German women? Then great, you'll probably pass the test. But the intonation, the way in which this question is structured, leads you to assume that the immigrant might say something different. Would that person say that they would lock them up, beat them? What is the basic assumption in structuring the question in this way? Isn't it a sense of that immigrant, that newcomer, as a stranger, as a threat, as a risk factor, as something that might deeply corrode the liberal values of the recipient state? So this is the first question. Let me just give you the sense of another question. The second question is this. Imagine that your adult son comes to you and declares that he is homosexual and would like to live with another man. How would you react? Now, I come to you from Canada. It's one of the most progressive countries in terms of same-sex marriage, and obviously the US too now since last week. But no government agency that I'm familiar with in Canada or the US would dare ask such a question. It's not a question that asks you about your knowledge of the law, about your willingness to comply with the law. It's a question that asks you about your personal belief. How would you respond if your child said X or Y to you? People might respond in different ways. Why is it the business of the state to even inquire about your personal belief in that context? So I want to suggest to you that citizenship tests generally are, of course, legitimate. As I said, we have them for many, many years in other jurisdictions, but there's a distinction between asking about your knowledge of the law, your ability, your willingness to comply with the law, and questions that go to inner belief, that go to your inner faith, and in that sense remind us not so much of a liberal state as much of a confessional state or an inquisitorial state, and that's a very different kind of state than the liberal state and the liberal values in which are the basic justification typically given to these kinds of tests. So I could give you a few other examples, but hopefully the gist of the argument is clear. Now let's imagine or think about another way of seeing how cultural pretexts are used as boundaries, symbolic boundaries of inclusion and exclusion. And the example that I will give you, this additional one, refers to questions of laws which some of you might be familiar with, laws that ban either the hijab, which is a face cover, a head cover that some Muslim women wear, or the niqab, which is a more extensive covering which covers the face, usually worn by more conservative Muslim women. So in such cases, I want to suggest to you these public laws are doing another kind of work of rebordering. So this is a different shifting border. No longer does it attach to specific territories or extends them inside or outside of the territory. Here we actually find the shifting border attaching to certain bodies, certain people who are seen to violate the basic values of the admitting state, who are people who, on the basis of their difference, are deemed either unfit or unwilling to join the political community in which they reside. Now, many of you would be familiar with France's law, which was introduced in 2010, which bans face covering. That particular law was actually upheld by the European Court of Human Rights recently in the SAS decision. But if you recall, the legal ramification in France of breaching that law are typically a monetary fine, and in some cases, you're also obliged to sit in a mandatory citizenship test to teach you in a way what the good citizen would do. But I want to tell you about another change which you might be less familiar with. And this is a proposed legislation from Quebec. And this is actually, you'll see the image here on the top of the second page. This proposed legislation was called the Quebec Charter of Values. It was introduced in 2013. It did not pass into law, but we now have a new version of that law now passing or being debated in the Quebec legislature again. So we have not seen the end of this story. But here, what is interesting is that we have seen a different way of thinking about these shifting borders. No longer is the debate only about whether or not women should be permitted or not permitted to wear a headscarf or a face veil. Here, the debate has shifted to provision and reception of public services. So what Quebec is proposing is a twofold change. First, public employees will not be permitted to wear any kind of religious symbols, which, as Quebec's legislation puts them, are ostentatious religious symbols. And if you look at those, these are the ones which are duplicated in the bottom part of this image. So a Sikh turban, a large cross, face veil, head cover, or a Jewish kippah would all be prohibited. All of these would be seen as breaching the neutrality of the state. So that's one part of this change, the public employees component, and you might say legitimate for a state to say that it should be neutral. We might debate whether or not that is a permissible use of public law. But the more interesting component, the second component, would be to say that anyone who has, usually any woman who has her face covered, would not be permitted to receive any kind of public services. She could not enter a courthouse, even a public school if her kids are enrolled in that school, because by virtue of covering, she would be breaching the vision of the public, of the demos, of the community in which she resides. Now, as I mentioned to you, this never passed into law, so we don't know if this ever reaches the Supreme Court of Canada, whether this would be considered constitutional or not, but this is a live proposal. Again, just to give you a sense of how these cultural borders are occurring And I would say that this is quite a dramatic suggestion. Not to provide any public services arguably is a relegation to second-class citizenship and discrimination on the basis of the combined factors of religiosity and gender. So we will have to see what happens with this narrative as this legislation, proposed legislation, continues in its legislative process. Whether or not it will pass is still an open question mark. So to some extent, talking about these cultural dimensions is obviously charged. People might have different opinions about what is the right position that a state should take. I would be the first one to admit that. I have written extensively about these issues. I believe they're deeply charged, and I don't believe there's a one-size-fits-all, and different communities might come to different conclusions. That said, there must be some general basic principles that could guide us in terms of defining what is the right position, what is the position that a liberal state should take. Can jurists and theorists provide us any guidance in terms of what's the right balance between, say, gender equality and religious diversity? And to some extent, these questions are the toughest that we faced in the sense of requiring us to explore in a world of uncertainty how really can we live in peace together collectively in our ever more diverse societies. And it is a difficult question. As I said, this is precisely the question that the court raised in SAS. I believe they asked the right question. I don't think they provided the right answer. But the question of how to deal with diversity is a real one. It's a challenge one. It's going to remain for us in the years to come. And I could speak about these issues for hours, but really, given that our clock is ticking, I want to turn to a third and final component of change, the economic or competitive dimension of the reconstructed border. And up until now, what I've described to you, really in a nutshell, is the restrictive turn, the way in which states have made it harder and harder for certain people to become members, and for certain people to even enter their communities in the first place, so they cannot even begin the process of becoming full members. But, and this is the interesting but, there's also another equally important process that is occurring simultaneously just at the same time, which I mentioned to you earlier, and this is the process of selective openness. So here we find countries, the very same countries that impose these restrictions that I've described to you, are actually quite explicitly opening their gates, proactively recruiting what they see as the best and brightest. They're trying to lure the highly skilled. They're trying to lure professional individuals, globetrotting individuals, wealthy individuals. And all of these individuals would fall under the category of wanted and welcome migration. And interestingly enough, the main tool which is used to advance this selective openness, just as we have seen with restrictive closure, is the whole range of tools of legal innovations. So I could give you a host of examples. I've listed some on our handout. The UK has introduced what it calls the exceptional talent category, its tier 1 category. The United States has its O1, what's referred to as the genius visa. Canada, various other countries in the Commonwealth or OECD, but I also want to give you other examples from beyond that. China, for example, has what it calls the 10,000 Talents Program, which tries to bring in the best and brightest from the world, so actually reversing the traditional brain drain. And there are many, many, many other legal examples which I could have recited to you. But in all of these cases, what countries are trying to do quite explicitly is to recruit what they see as potentially the best people who would be able to lift a country's image, allow it to play on the world stage, increase its relative advantage, etc., etc. Oftentimes we'll find this occurring, the most mobile people, or the people who are most desirable in this new dictionary of migration, are top scientists, for example, top artists, top athletes, and I could give you a whole set of examples later on during the Q&A. But what is interesting to see is how governments, again, the very same governments who would bring in these restrictive measures, would use, again, the tools of law, just different aspects of law, to try and recruit the best and brightest in this new global race for talent. And literally almost every country now that wants to play on the international field, that has international aspirations, is using these new either swift naturalization processes or just new entryways to bring in those individuals which are seen as in high demand and highly competitive, these rising stars. And just again, to give you a concrete example, there are many people in the world of sports who are recruited across these international boundaries. But even if we think about academia, think about the changes that we have seen in recent years. So many people are transitioning across borders, and you need, of course, to have great institutions that would bring individuals in. But you also need to have visa changes, visa categories that would allow people to settle in quite quickly in order for this to occur. And actually think about the personal histories of some of the people in this room. They actually really exemplify this notion of being members of this new category of international mobility, what I've elsewhere called Olympic citizens, people who really have the ability to move across borders based on their talent, based on their merit, based on their expertise. And I don't want to criticize this trend. I think in many ways it's a very logical position for states to take. But the puzzle that I want to present to you is that nothing in our conventional stories about the demise of citizenship or the decline of borders actually explains these kinds of developments, either the restriction or the selective openness. So this is the puzzle that we are facing. We just don't have a current explanation, at least not for the eagerness of governments to invest citizenship literally in individuals with the expectation of a return, either reputational or otherwise. So in this new world order, if you unfortunately belong to the huddled masses yearning to breathe free, those immortalized in the new Colossus, if you wanted to relocate and start afresh, say in the United States or any other legendary country of immigration, you would probably be disheartened, you would be disappointed to learn that the Golden Gate is no longer open. In fact, it's quite shut closed. It only remains open for those people, for the select few, especially those with extraordinary talent, as I mentioned, in the sciences, arts, and sports, and increasingly those with deep pockets as well. So it is time to take stock. And let me just summarize what I've introduced to you and close there. I have argued that in our world of increased insecurity, states have not lost their control over their membership boundaries. Instead, what they have done is they have reinvented, they have transformed our concepts of borders and membership boundaries in a far more sophisticated, multi-layered fashion that goes to the heart of the definition of who belongs. And public law, especially in its regulatory, in its law and order kind of guise, plays a central role in this tripartite, in the territorial, cultural, and economic transformation of citizenship. It creates tremendous opportunity structures for some, while delimiting access and opportunity for others. Given these features, the constant reinvention, or as some have put it, the near obsession of wealthier countries with migration and border control, invites our critical reflection in terms of the human rights and human dignity implications of these changes, in terms of democratic accountability, and also in terms of inequality in access to membership, either at birth or later on in life. And let me close with the following thought about public law in an uncertain world. Former Chief Justice Aharon Barak of the Israel Supreme Court, who was my judge when I clerked for him many years ago, famously stated, "The world is filled with law." We are in a room here with, what, about 300 lawyers or so? So obviously the world is filled with law. This means that we would have at least 900, if not 1,200 interpretations of what this phrase might mean. Is it just descriptive or is it normative? Is it both? Is law constitutive of the world or is it merely performative? What is law and the world to begin with? Should we adopt a textualist or a purposive interpretation? Actually, the last one is pretty easy. For Barak, it was always purposive, no matter what the text said, so that's besides the point. But the point I want to draw from Barak's statement is somewhat different. Even if the world is filled with law, we do not yet know which aspect of law it is filled with. Is it the vision of regulatory law, law and order kind of law that I have described to you with the territorial and cultural components, a vision of law which seems to undercut rights, to undercut protection obligations which states otherwise would have under their domestic and international law, restrictions of rights which affect the most vulnerable migratory populations, the populations that are most in need of laws, protection? Or is it the vision of public law that could restrict the exercise of executive power, that could actually call truth to power, that could actually require governments and other authorities to use their exercise of power in a way which is more justifiable? If Justice Barak is right in his assessment that the world is filled with law, then the task falls on us, the privileged professional elites who actually are trained in the statecraft of the profession of law. We need to decide every day, every moment, in every action, whether we will pursue and perfect the rights restriction dimension of public law, or whether, even in the face of public pressure, even in the face of conditions of deep uncertainty and heightened risk, if we were to find the courage, the determination to deploy the tremendously rich toolbox that public law provides us with, to contribute to the betterment of the lives of those who are most in need of law's protection. The world is filled with law. Kol ha'olam mishpat. The question is, what do we make that world to be? Thank you very much. Let me stop here.
So we've got about 10 minutes. So let's take 2 or 3 quick questions or comments, not speeches, and then let's invite Ayelet to respond. Yes, sir.
I'm wondering.
Could you stand up, please?
Excuse me?
Stand up so people hear you.
I'm wondering how the description of changes that you provided us interreacts with the EU's rules for each other's citizens.
And we'll take another comment. Yes, please. Is there a microphone? So just next to you.
Thank you so much. Thank you so much for the great speech. So maybe we could try to think and to reflect on the content, maybe the legal rights associated with citizenship. It is going to be basic human rights, or if we can develop further. As the previous speaker, I'm from Europe, so I'm more concerned and familiar with European citizenship. And at the same time, going on with this same topic, maybe I would like also if you can say us about global citizenship. We can go further, I don't know, basic. Here, this last week here in the US, we had this big for the same-sex marriage, and then for the Affordable Care Act, which has, we can see that under a national perspective, or we could go through more like global aspects. Thank you.
Yes, one last question here in the front.
My question is, don't you think that your perception of citizenship is ability set? Because it does not recognize normality. And persons with disabilities, even if they are staying in any country, they face citizenship that, for example, we often use the derogatory phrase, persons with unfoundness of mind. What more problematizing citizenship from the top of the government?
Thank you. Ayelet, let's take a reply to this. If we have time, we can take 1 or 2 more. Otherwise, we'll go for coffee.
Thank you so much for these questions. So for the first question, the relationship between, if I understood you correctly, the question of EU's dilemmas between internal solidarity and external restriction. Unfortunately, this is such a topical question now, obviously with thousands drowning in the Mediterranean Sea. So it's a big dilemma for Europe. I don't wish to propose to speak on its behalf, either any one of the member states or the European Union qua union. But I would say that in order to have some coherence in terms of the values that the EU speaks for, these values should also be expressed not just only internally in terms of greater solidarity, but also to some extent externally. I still don't want to suggest to you that there's an easy answer, because you could just say, why not have the most expansive open borders kind of a question. That already leads us to my response to the second issue, the second question that was raised. So I would not preach global citizenship, or at least not as a replacement of current regimes of citizenship. I would be all in favor of having a cosmopolitan notion in terms of rights, basic protections for everyone, for persons. But given the current structures that we have in the world around us, I don't hold the belief that giving up citizenship as we know it would actually contribute to the rights and protections of the most vulnerable. I think it would expose those who currently have some protections to just reduce the kinds of protections that they have. We don't yet have institutions or ways of ensuring that any kind of world citizenship, again, if it were to replace the current structures of citizenship that we have, would really replicate anything that we're familiar with in terms of a holistic kind of rights protection. So that's partly the dilemma we face. We want to have, I would argue, we should be in favor of some baseline protection for every person by virtue of their personhood, still have some kind of regimes of political participation which are bounded, but how to address this tension between universal protection and more particularized structures that we have is, again, one of those great dilemmas which hopefully in our generation will be resolved, although I doubt it. We'll have this tension probably going on for many, many years to come. On the last notion of disability, there are many, many writers who are talking about this. We could have, in theory, Will Kimlicka, for example, has written about a broader conception of citizenship, which would actually begin from questions of disability rather than end with them. So there are different theories that would try and address these kinds of issues. Again, this goes beyond the specific topic of my presentation here today. Any other questions, or should we close?
So what a wonderful talk. Thank you. I'm thinking about law, the domain of law. And you propose two models that we're seeing, regulatory and exclusionary of the poor and rights protecting. And I'm wondering if you want to say anything about the degree to which law will rest on politics, and what, if anything, as lawyers we can do or should do to affect democratic understandings of these issues that play out in the world of politics.
Thank you. I really appreciate that question, because to some extent, if we had a debate about the extraterritorial effect of rights, if you look at that debate in international law, actually more than in any domestic law, typically the kind of argument is law has the ability to protect rights, but it's politics that's restricting it. So it's a very kind of marked distinction that you would find there. But I want to challenge that. I actually want to work with your idea. What could be done? Because the two, if they are more interrelated, if ideas affect politics and policies and law, if social changes affect law, if law affects social changes, if we take a much more dynamic kind of interactive vision of law, which is the vision that I have, then I would have to say that my answer has to be twofold. What we can do is put out great ideas. That is, if you put out great ideas, hopefully over time, eventually, it might take years, it might take centuries, decades, who knows, these ideas might matter. I mean, if you brought the example of same-sex marriage. This is something which 50 years ago probably would have been totally inconceivable. It required a good amount of ideas, of change. Not everyone agrees with it. Nonetheless, this is a great example of a change which, if you think about it, really, historically, it's a change which occurred in an instant. Of course, it didn't feel that way for people who had no rights. But the possibility of change is real, I think, proved in various examples. And for our context, the dilemma, the reason why I think it's more complicated than other issues, and I'll close, I know we're tight with time, is because the question is who will speak up for those individuals who currently have no right to speak in those communities which are affected by their potential presence. And this is why I started with the quote about anxiety. And I said it's really not, it's not the numbers. That is, if you were to look at the reasons for Australia introducing its excision policy, there were 300 people who arrived, what in Australia are referred to as boat people, people who arrived without permission and reached Australia's shore. And there were potentially other boats on the way. But the numbers were minuscule, they were tiny, they were small, but it didn't matter, because what mattered was the sense of loss of control. And the question is, how do you counter that sense, that fear? And remember, the voters are people who already are full members. They're not those individuals who might wish to come into a given political community. So again, I don't want to offer any quick fix or simple answers, but there has to be a constituency, there has to be some voice. Someone has to speak on behalf of those who have no rights currently. But in a way, there's nothing new. The whole story of constitutional law, of its expansion, or public law and its expansion is that story. Women didn't have a right to vote. I speak here to you as a keynote lecture today. So obviously change has occurred. Someone had to motivate that. Someone had to fight for it. Someone had to bring it about. So again, as I said, no easy fix, but someone has to have the ability to speak for what we would typically say for the voiceless, for the people who currently are not represented. And there's no better example than people who are not yet in the political community, because formally they have no voice, and they should have, some would argue, no voice. So this is the challenge that I think is bestowed on us. That's why I said it's our responsibility to think about these ideas, to come up with them, to speak up in favor of individuals who have no rights. But that, again, it's my own personal position that ideas do matter and that changes could occur over time. So I'll end hopefully with this optimistic note. Thank you.